AILA colleagues. My name is Michelle Mendez, and I'm the director of the Defending Vulnerable Populations program at Clinic. I am a longtime AILA member, and in fact, I worked at AILA before law school, so I know very well how valuable AILA resources are to your immigration practice. And speaking of valuable AILA resources, our Defending Vulnerable Populations program team recently updated the 6th edition of the Representing Clients in Immigration Court book. Because no one does this important immigrants' rights work alone, I want to recognize our team. Vicki Nielsen, Rebecca Schultz, Bradley Jenkins, Amy Mayer-Salins, Rachel Nagar, and Ann Garcia. Our trusted consulting attorneys are retired immigration judge Denise Slavin, Katie Lewis, and Tanika Vigil. The 6th edition of Representing Clients in Immigration Court incorporates the many changes brought to removal defense practice by the Trump administration and now by the Biden administration. Our team added 2 new chapters, one on motions to reopen and another on immigration court strategies for respondents who are simultaneously pursuing relief with USCIS, a total of 17 chapters. Our team expanded the 15 chapters by discussing current procedures, citing to new policies and legal precedent, and explaining ongoing lawsuits. We also revamped the appendices to include lots of timely and useful samples, such as a BIA motion to expand the page limit. This sample in particular is a lifesaver because you won't know if you've exceeded the page limit until perhaps the last minute. And you won't want to spend that very valuable time drafting a motion to increase the page limit from scratch. You'll want to spend that time on the all-important BIA brief. Overall, Representing Clients in Immigration Court will provide you with the clear and strategic guidance that you need to help you prepare for your next immigration court proceeding. This book focuses on representing clients in immigration court, as the title suggests. But all practitioners would benefit from this book, regardless of their specialty or practice. Practitioners who practice solely before USCIS or do solely consular processing may have cases that turn into removal defense cases at any moment. All immigration practitioners must therefore be able to pivot into removal defense mode, and this book will allow you to do so. Even if you never have to pivot into removal defense mode, it's essential for all immigration practitioners to be able to provide consultations to those in removal proceedings and to refer cases to colleagues who are competent in the particular removal defense strategy that you've identified. This book covers basic nuts and bolts procedures as well as advanced strategies for those who have been practicing for years. There is no other book devoted only to removal defense practice that I know of. This book is comprehensive, covering topics such as criminal grounds of inadmissibility and deportability, waivers, cancellation of removal, bond hearings, asylum, withholding of removal, and protection under CAT, trial skills, prosecutorial discretion, and administrative review of removal orders. Our team has covered these topics in a clear and approachable manner so that you, the reader, understand these complex topics and can apply our tips, strategies, and practical advice to your practice. With this book, you should be able to place removal proceedings into the larger context of immigration law, understand the function of removal proceedings, and ultimately navigate a removal defense case from start to finish successfully through the information in the text of the book, as well as the timely samples in the appendices. Thank you for your desire to learn and to be the best advocate for your immigrant clients.